Morning, Mr. Hartman.
Morning, Your Honor. Apologize for being late.
No problem. This is file 25-93362FH for docket call. We've got Mr. McLennan here for the people, Mr. Hartman for the defense appearing by Zoom, and Mr. Morel is present in the courtroom. And for docket call purposes, Mr. Hartman, where are we at on this case? What's our status?
Your Honor, I received the transcripts. I'm in the process of drafting a motion to quash. I would like the court to hear that. And I guess I can, the court would give me, a week to file it and then schedule a date that we could hear that. And then after that, we can decide which way the case is going to go toward resolution or trial.
Okay, my next motion day here is September 8th. If you can get that filed within the next week, then that'll give the prosecutor time to file the response. So we can continue the docket call to September 8th at 10:30. And you can notice up any motion to quash or motion that you want at that time. Anything else for purposes of today, Mr. Hartman?
No, Your Honor.
Mr. McLennan?
No, Your Honor.
Okay, Mr. Morel, we'll see you next on September 8th at 10:30 in the morning. And your attorney will likely have filed a motion for me to hear at that date and time as well.
Okay, thank you.
Okay, have a good day, Mr. Hartman. And it will be Carol Poliandro. It's file 24-93328FH. Counsel, you want to state your appearances, please?
Zachary McLennan on behalf of the people.
Your Honor, Mike Vogler representing Carol Poliandro.
All right, and Mr. Vogler, have you had a chance to review the probation violation report and recommendations with Ms. Poliandro?
Yes.
Do you have any additions or corrections to that report?
No.
The advisory guidelines range had initially been scored at 0 to 6 at the sentencing. Is there any reason to revisit that scoring?
I don't think so.
Okay, Mr. McLennan, any additions, corrections, or scoring challenges from the people?
No, Your Honor.
Mr. Vogler, go ahead with any recommendations you'd like to say on behalf of.
Judge, I think that we're coming up with 78 days credit at this time.
The report had her at 84 days. I
Oh,
think.
did it?
Yeah.
Okay. Yeah, you're right. My math is wrong. So I know Carol as I think she's got difficulties that are more personal in nature that I think if she would solve those, she'd probably go a long way to solving the problem that brought her here, this continued use of drugs. I mean, her past, she had talent, she had good jobs, skills. Even I remember when she, I don't know if at the beginning or in the middle of the case, she had a good job at the grocery store in Onaway. Was a trusted employee, ended up losing that employment mostly because of what she's been and gotten herself involved in. But through the course of this, I think at least she did come out of the Sunrise Center. She learned something there. She just has not yet been able to put what she learned into good practice. But I think probably she would be very wise to visit her relationships with other people and make some choices there that would probably help her in the future to avoid this kind of thing.
Thank you, Mr. Vogler. Ms. Poliandro, you don't have to make a statement today, but you're allowed to. Is there anything you want to tell me or no?
I don't think so at this time. I spoke with the parole probation officer, and I think most of what I said to her is probably what I would just say to you again. But no, I just not at this time.
Okay,
But thank you.
thank you. Mr. McLennan, any recommendations for the people?
Yes. Your Honor, defendant was sentenced in January and to Swift Insure and 7411 status. And things appeared to be going well until April. And since then, we've just had tremendous difficulty with numerous violations. And I can understand and appreciate a lot of what Mr. Vogler has said about defendant. But at this point, Your Honor, with the repeated violations, the people would recommend following the recommendations of the report to revoke the 7411 status and discharge on 6 probation.
Thank you. Well, Ms. Poliandro, this is, not the kind of case where I wanted you to have a felony conviction or to spend much time in jail. At the initial sentencing, the probation agent at that time, because of some of the problems you had on bond, said they did not, the Department of Corrections did not support 7411 for you. I did it anyway to try to give you a chance to avoid that felony conviction. We placed you in the Swift Insure probation program for some intensive kind of probation. We've had a lot of problems with you in that program, not just use, but also failing to report, failing to test. We tried sending you to rehab. We've given you some short sanctions, and through those, we didn't revoke your 7411. So I think there's nothing more that we could have done to try to communicate to you that if you wanted to really address these problems, we were going to partner with you to do that. But at some point, we can't make you get sober.
Right.
That's on you. We can give you tools and resources and a structure to do that. But if you are uncooperative with that, and sometimes I think that was out of fear, you didn't want to show up because you're going to jail. Or, I mean, I understand that, but you weren't working with us as much as we were willing to work with you. And I understand what Mr. Vogler's kind of hinting at is you've got some people in your life that are not helping get you in that right direction. You have very tough choices to make about it. None of those folks are going to do a day of your time for you. They don't live your life. You live your life. So no matter what those relationships are, you got to decide what kind of life does Carol want, and go out and get that life. And if that means making some hard choices with people, that's oftentimes what it means. I think everybody hopes that you'll do that. But at this point, we have really tried to give treatment options on this, and it just has not worked, and you've not cooperated. So now we've got the only other tools in the toolbox are what's recommended today. So it certainly doesn't make me happy to do that at all, but these are totally appropriate recommendations. At this point, given your lack of compliance on probation, your multiple violations, I'm going to revoke your deferred status, and we're going to enter a judgment on the felony conviction at this time. I'm also going to revoke your probation in order that you serve 6 months in the Prescott County Jail. I will give you credit for 84 days previously served. I would approve you for any kind of trustee status or any programming that the jail would have with any credit programs they would have for that. And also any fines and costs that were assessed that they remain due and owing in the amount of any unpaid balance. Ms. Poliandro, because we are entering a judgment on the case now, you can file an application for appeal if you want. If you wanted a lawyer, I'd give you one, but you'd have to ask me in 6 months. We're going to hand you a piece of paper explaining that process and ask you to initial one copy for us. So we have a record, we gave it to you.
Okay.
And the other one is for you to fill out if you want to take it.
Okay.
When you're released from the jail, you're not on probation anymore. And then you got to decide what you want to do. And if you need any help, still reach out to folks that'll try to get you into treatment before you catch a new case.
Okay.
Okay. Good luck.
I'm gonna have to print one. I'll take it.
Okay, we'll get one down to you. All right, good morning. We'll go back on the record in the 53rd Circuit Court for the County of Presqu'île. And we are providing public access both in the courtroom and also online. And we have a civil case for pretrial Trudgeon v. Weckworth, file 25-3395CH. Come forward, counsel. Counsel, you want to state your appearances, beginning with plaintiff?
Yes, my name is Kathleen Kerrigan. I'm appearing for Mary Trudgeon, Denise Shook, Wayne Wetworth, and Renee Rogers.
Good morning. Victoria Padula appearing on behalf of defendant Roy Weckworth, who is present in person in the courtroom today.
Okay, and good morning, Mr. Weckworth. You can have a seat at the table if you wish. All right, so we're here. We just did a scheduling order last month. The parties told me they were moving this case along pretty quickly. Ms. Kerrigan, on behalf of plaintiff then, where are we at in terms of status of any resolution or readiness for a trial?
So they will receive our disclosures today. Then we'll send proof of service to the court. We haven't heard back from our most recent settlement offer that last I heard from the other party was just before our previous hearing. So there may still be hope of settling, but we're preparing as if we're going to be having trial.
Ms. Padula, what can you tell me about that?
Yes, Your Honor, everything Sister Counsel has expressed is accurate. We are just working with, we do anticipate, to move forward. Hopefully we're going to reach some sort of agreement here shortly. We do anticipate responding very, very soon, if not today. We're hoping that we are able to resolve this matter, but in the event that we are not, we will proceed as scheduled and don't anticipate any further adjournments or additional time at this current date.
Okay, well, let me ask you, I mean, I had the case on kind of a fast track because that's what you guys told me you preferred. So I can continue the final pretrial either to September 8th, which is only about 4 weeks out, or to October 6th, about 8 weeks out. What's your preference, Ms. Kerrigan?
September would be our preference.
September fine with you, Ms. Padula?
That's no problem, except I believe that my client is going to be out of town in the beginning of September, so I'm not sure if that will be ideal for that reason alone.
Okay, Mr. Weckworth, September 8th, is that the day you're available or no?
No,
Okay.
no, sir.
All right, well, we'll continue the pretrial to October 6th at 11 a.m. then.
Thank you.
And Zoom appearances are allowed by any parties that wish. Anybody that wants to be present in the courtroom is, of course, welcome to do that as well. So we'll set it for October 6th at 11 a.m. Anything further from plaintiff?
No, thank you, Your
Anything
Honor.
further from defense?
Nothing further, Your Honor. Thank you.
Okay, have a great day.
I'll take.
So back on the record, and we have next people be twos, file 89-91188. Counsel, you want to state your appearances, please?
Zachary McClellan on behalf of the people.
And good morning, Your Honor. Christopher Parks on behalf of Mr. Tews.
And I spoke with counsel at the bench. Mr. Tews has an application to set aside a 1989 conviction in this county. And he has some convictions in another county that are still being sort of sorted out some of the details. So as I understand, Mr. Parks, you'd like about 60 days to sort out what's going on over there. Is that right?
That's correct, Your Honor.
Any objection to that, Mr. McClellan?
No, Your Honor.
All right, so I'll continue this then to October 6th at 11:10 a.m. Anything further from the petitioner?
No, Your Honor.
Good morning. Are you Harold Middleton?
Yes.
All right, so this is People v. Harold Middleton, file 25-70550FH for arraignment. Counsel, you want to state your appearances, please?
Anthony Julie on behalf of the people.
No, not Gauthier from Mr. Middleton, who appears remotely from the Chippewa County Jail.
Okay, have you had a chance to review the charging document with your client?
I have, Your Honor. He did not want to waive any sort of formalities or readings. At this time, he wants a formal arraignment conducted.
No problem. All right, Mr. Middleton, are you Harold Stanley Middleton III?
Yes.
All right, Mr. Middleton, you are charged in a felony information with 3 counts as well as a habitual 4th notice In count one, breaking and entering a building with intent. It alleges that on or about May 6th, 2024, in the village of Wolverine, Sheboygan County, that you did break and enter a garage located at 5734 Cedar Street, Wolverine, Michigan, 49799, with the intent to commit the crime of larceny therein. That would be a felony punishable by a maximum of 10 years in prison. The prosecutor has filed a notice that you have been previously convicted of 3 or more felonies or attempts to commit felonies, in that on or about April 19th, 2022, you were convicted of possession of methamphetamine in the 50th Circuit Court for Chippewa County, state of Michigan, and on or about April 19th, 2022, convicted of malicious destruction of fire or police property, again in Chippewa County, state of Michigan, and on or about April 23rd, 2024, you were convicted of maintaining a drug house in the 50th Circuit Court, again for Chippewa County, state of Michigan. With that habitual offender notice, that would increase, in the court's discretion, the maximum penalty for the B&E on count one from 10 years to a maximum of life in prison. Count two, larceny, $1,000 or more, but less than $20,000, alleges that on or about the same date and location as in count one, you did commit the offense of larceny by stealing a 2010 Ford F-150 that belonged to a Lance Michael Harmer. The value of the property stolen was $1,000 or less, $1,000 or more, but less than $20,000. That would be a felony punishable by a maximum of 5 years and or a $10,000 fine, or 3 times the value of the property stolen, whichever is greater. However, with the habitual fourth notice, that would again increase the maximum penalty in the court's discretion to life in prison. Count three, motor vehicle unlawful driving away, alleges that on or about the same date and time as counts 1 and 2, and at the same location, you did willfully and without authority take possession of and drive or take away, or did assist in or was a party to such taking, possession, driving, or taking away of a motor vehicle, to wit, a 2010 Ford F-150 belonging to another, to wit, Lance Michael Harmer. That's a felony punishable by a maximum of 5 years in prison and a suspension of your driver's license by the Secretary of State. But again, with the habitual fourth notice, in the court's discretion, the maximum penalty could be increased to life in prison. Mr. Middleton, do you understand the maximum penalty of the charges against you, or do you have any questions for me or your lawyer about them?
No, I understand.
Okay, and Mr. Nightingale, how does Mr. Middleton wish to plead to those?
Not guilty.
Counts? Okay, we'll enter a plea of not guilty, Mr. Middleton, as to all 3 counts, and Mr. Nightingale is a forensic center referral requested.
No, Your Honor.
What would be the estimated length of trial?
I would say 2 days.
Okay. And I did see there was a preliminary examination in this matter, and a transcript prepared. Are you anticipating motion to quash?
I am, Your Honor. I will file it as soon as I can get it drafted.
Okay, we can set this then for a docket call, and you can notice up a motion to quash on September 30th at 10:30 a.m. And is Mr. Middleton expected to still be in the Chippewa County Jail at that time?
He will be in the jail still at that time, yes.
Okay, we'll have that be a Zoom appearance on his part. Anything further from the defense?
No, Your Honor, thank you.
Anything further from the people?
No, thank you.
Okay, Mr. Middleton, your lawyer's going to file a motion challenging at least 1 or more of the charges up here, and we're going to hear that motion and have you zoom in on September 30th at 10:30
Okay,
in the
but I
morning, right?
would like to be there. I could,
You'd like to be there in person?
yeah.
All right, well, I'll have you talk with Mr. Nightingale about that between now and then. I think it's not required that I would have you be in person for that, since it's just some legal arguments. But if he wants to make that request, I'll discuss that with him and the prosecutor beforehand. All right, otherwise we'll probably have you zoom in. I'll see you then, sir.
And I would like my discovery pack as also.
Okay, Mr. Nightingale, have you been provided with discovery?
Yes, Your Honor.
I would
Mr.
like
Middleton,
my
it should be on the way to you.
transcripts from my
I think it got mailed out late last week.
So, Mr. Middleton, when you're represented by an attorney, then the prosecutor doesn't present it to you directly. They give it to your lawyer. He's indicated he has it and he's getting a copy out to you. Anything else?
Oh, just waiting on my discovery pack that I've been waiting on for a while now.
Okay.
I mean, it
All
is
right.
my
Well, you
right to
should-
have it, so,
Yep, and your lawyer's got it and he says that it's on its way to you.
okay. I would like
All
my
right,
other,
let's-
my transcript for my preliminary exam too. I'd like all that too.
Okay. Well, again, that's stuff you'd request from your lawyer, not from me. He's got it
And
and
I've
he's
been
representing
requesting.
your interests. Okay. All right, you have a good day, sir.
Yep.
I'm going to call Mr. Warner's case. It's the People versus Keegan Warner, file 25-7004FH. Got Mr. Warner in the courtroom with his lawyer, Mr. Andriaki, the prosecuting attorney, Ms. Goodrich, for the people. We're here for a docket call. Mr. Andriaki, how are we proceeding, sir?
Your Honor, with me entering a plea if I may approach, but ask the look at.
Mr. Warner, would you please stand and as best you can, raise your right hand for me, sir? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
You can be seated. Are you Keegan Ray Warner?
Yes, sir.
Okay, Mr. Warner, a guilty plea hearing is an important event. It includes the waiver of constitutional and other rights that you have. So I want you to listen carefully. At any time, if you have a question, ask me. I'm happy to answer. If you need a minute to talk to your lawyer, you just let me know. We're happy to give you that time. Is that all right?
All right.
Now, I have to advise you of the maximum penalty that you could face for the charges you're offering to plead guilty to today. And that would be counts 3 and 4. Count 3 is using a computer to commit a crime with a maximum of 4 to 10 years of the underlying crime. That is a felony punishable by 7 years and or a $5,000 fine with reimbursement for the costs for government expenses and a discretionary consecutive sentence for the underlying conviction. Count 4 would be the underlying conviction accosting a minor for immoral purposes. That would be a felony punishable by a maximum of 4 years and or a $4,000 fine. There's mandatory AIDS and STD testing. And there's, it would be a tier 2 offense under the Michigan Sex Offender Registration Act, unless you have a prior tier 2 offense conviction, in which case it would be a tier 3 offense. So the discretionary consecutive means that the maximum exposure you would have would be the 7 years plus 4 years or 11 years maximum in the state prison. Mr. Warner, do you understand the maximum penalty allowed by law for those charges?
That's right.
Are you on probation or parole anywhere?
Not currently.
Okay, were you on bond for any other cases at the time of this incident back in October 2024?
No, Your Honor.
Okay, did you read and understand the rights listed on the advice of rights form?
Yes, Your Honor.
And did you sign that form today?
Yes, Your Honor.
Do you have any questions for me or for your lawyer about any of those rights?
No, Your Honor.
Do you understand that if you plead guilty, you'll give up all those trial rights and you won't have a trial of any kind?
Yes, Your Honor.
And is that what you're choosing to do today?
Yes, Your Honor.
All right, if I accept your plea, you're giving up any claim that the plea was caused by any threats or by any promises that are beyond the terms of the agreement. Do you understand that?
Yes, Your Honor.
Also, when you plead guilty, you give up the right to appeal. And if you wanted to appeal, you'd have to seek permission to appeal. You would do so by filing an application. Court of Appeals would not have to hear your appeal at all. If they did decide to hear your appeal, the types of issues that you could raise are very limited after a plea, much more limited than if you were convicted after a trial. Do you understand that?
Yes, Your Honor.
The plea agreement provides that in exchange for your plea of guilty to counts 3 and 4, the prosecutor will dismiss the remaining charges. Do you understand the terms of that plea agreement?
Yes, Your Honor.
Mr. Andriaki, is that a full, fair, and accurate statement of the terms of the agreement?
Yes, Your Honor.
Ms. Goodrich?
Yes.
All right, Mr. Warner, other than the plea agreement, has anybody promised you anything to get you to plead guilty?
No, Your Honor.
Has anybody threatened you in any way to make you do so?
No, Your Honor.
Is entering this plea your own free choosing?
Yes, Your Honor.
Knowing all this, how do you wish to plead the charge in count 3, using a computer to commit a crime punishable by at least 4 years?
Guilty.
How do you wish to plead to the charge in count 4, accosting a minor for immoral purposes?
Guilty.
So, Mr. Warner, back on October 1st of last year, 2024, did you have some communications with a person who was located in Sheboygan County?
Yes, Your Honor.
Was that person less than 16 years of age?
Yes, Your Honor.
Did you know that that person was less than 16 years of age?
Yes, Your Honor.
Were you using a computer program or a computer device to communicate with that person?
Yes, Your Honor.
Were you situated in Sheboygan County or no?
No, I'm in Abbott County.
Okay, but the person you were communicating with was in Sheboygan County?
Yes, Your Honor.
And during the course of that communication, did you have some communications of a sexual nature with that person?
Yes, sir.
Did you ask that person to engage in any sexual activity with you?
Some pictures. Yes, sir.
Okay. And you asked them to send photographs that would be of a sexual nature
Yes, sir.
of them in an unclothed state?
Yes, sir.
Okay. Mr. Andraki, are you satisfied with that factual basis?
Yes, Your Honor.
Ms. Goodrich?
Yes.
Mr. Andraki, are you aware of any other promises, threats, or inducements?
No, Your Honor.
And do you believe I fully complied with the requirements of MCR 6.302?
I do, Your Honor.
Ms. Goodrich, on both those questions, your thoughts?
Yes.
All right, and Mr. Warner, I find that your plea is knowingly, understandably, and voluntarily made, and that there's a sufficient basis in fact and law to believe that you are guilty of those offenses. So I do accept your plea. You'll have to cooperate with a pre-sentence report where you'll be interviewed by an agent from the Department of Corrections so they can make recommendations about what I should do with you. I would presume you want me to know more about you than what I just learned right now. There's 2 ways that I learn about that. One is through you and your attorney at the sentencing, and another is through this pre-sentence report where I learn more about who you are. So we'll schedule sentencing for September 30th. Mr. Andriaki, morning or afternoon work better for you?
Afternoon would be best, Your Honor.
Okay. How about 3 p.m. okay?
Perfect, Your Honor.
So we'll schedule your sentencing, Mr. Warner, for September 30th at 3 p.m. Anything further from the defense,
No, thank you, Your Honor.
from the people?
No, Your Honor, thank you.
All right, we'll see you then, sir.
Thank you, Your Honor.